Hi, I'm Irama Valdes, a probate, guardianship, and estate planning attorney. Probate. I use that a lot, and I guess I assume that people know what I'm talking about, but not everybody knows. So probate is actually a process by which the court changes title to property and oversees the administration of your assets and your debts after you pass. Simply put, if you've left assets in your name alone, those assets need to be distributed to your heirs or your beneficiaries. And probate is the case that's required to be able to do that. So when you die, if you have these assets that are in your name alone or are not in a trust, then a relative, an heir, a beneficiary have to open a probate case. They have to hire an attorney. That attorney has to create pleadings and open the case to let the court know that you've passed away and that assets need to be distributed to beneficiaries. Many of my clients ask me, well, what if you created a will? A will doesn't actually avoid probate. The only thing the will does is appoint a personal representative and also tell the court who you want to receive your assets. And you can do it in percentages, you can do it in amounts, or you can do it in kind. For example, you can say, I want this house to go to so-and-so. So the first step is appointing a personal representative. That's what PR stands for. Some states know it as administrator or executor, but here in Florida, where I practice, it's personal representative. After the personal representative is appointed, then you have to marshal and liquidate assets. So what does that mean exactly? Well, let's say you have a bank account and it was in your name alone and it didn't have a payable on death beneficiary. The personal representative has to take the funds in that account and place it into a restricted depository. Now, a restricted depository is like a checking account, but no funds can actually come out of that account without a court order. When I talk about liquidating assets, think of an asset that's not in liquid form. So for example, if you have a house or an apartment or a lot that needs to be sold, that needs to be done in the estate. Also, if we need to cash in any bonds or sell stock, all of that needs to be done by the personal representative. The next step in a probate is to pay the debts and settle litigation. When we're talking about debts, it can be anywhere from credit cards and utility bills to mortgage. Many times these debts, the companies that are managing these debts, FPL or Bank of America, if you have a mortgage, are going to file a claim against the estate, and that could end up in litigation. So they either have to be paid off or they have to waive their right to be paid off. Either way, that needs to be done before a probate can be finished. And there are other types of litigation as well. Let's say the person who passed away, referred to as a decedent, died in a way that wasn't kosher. Maybe there's a wrongful death suit or a nursing home negligence. That needs to be settled before a distribution can be made. And the last type of litigation that happens more often than not really is litigation between the beneficiaries. Sometimes there's a disagreement as to how the assets should be distributed, or sometimes you're fighting over a fraudulent will. In either case, you have to settle all of that before a distribution can be made. And then lastly, you distribute the assets. So most of the time when I have a webinar or workshop, I ask my clients, how many of you, the people that are at the workshop, how many of you don't have a plan? And about 80% of people, because they're there to learn, right, raise their hand and they say, oh no, I don't have a plan. And I always say, wrong. You're absolutely wrong. You do have a plan, and your plan is brought to you by the state of Florida. So if you don't have an estate plan, the state actually has a plan for you in the form of statutes. Now, they have created these laws to determine what happens to your assets after you pass away, who gets them, in what amount, what about spouses, what if you've disinherited someone, who should be the individual in charge. All of these things are laid out for you by the state of Florida. And if you're not okay with that, then you need to create a plan. For more information, feel free to check us out online at probatelaw miami.com.